Mhm. Mhm. Let to get started momentarily for those who are listening on YouTube. Mhm. Let to get started moment. Just a few more moments. All right, everybody. So good to have everyone here tonight. And I know we got a busy Friday night. A lot of different things are going on in our personal life, but it is good that we are here. And one of the things I wanted to discuss tonight, because I have been doing a lot of research, as I have stated previously, because I got some things going on in my personal life as far as book projects, things I have been working on outside of my normal apologetic normal course of action. But I wanted to address or pretty much just have a pretty fun group discussion tonight on a principle that comes up time to time as we're having a lot of fun interdoctrinal conversations. And usually it comes up when we're trying to understand different doctrinal positions. And one thing I always think is very important when we are endeavoring to do such is to make sure that we are using not only accurate representations of different varying expressions of doctrine, but using articulations of doctrine that do so in a meaningful and skilled way. And this is the principle of agency. And why the principle of agency is very important, or better yet, is risen to prominence, especially in these latter times, or as we see a resurgence of how we probably would articulate as maybe modern day Unitarianism, because we know there has been maybe cyclistic or cycles of Unitarianism, probably in the form of the Socinians and other various groups that have kind of historically risen to prominence. And then you had the early 1900s, and even in the United States, with some of our founding fathers in various groups. Unitarians have been present within the United States, and a lot of people aren't aware of that. Our founding fathers, early 1900s, and even with the merging of the Unitarians with the Universalists, that form what we are familiar with as the Unitarian Universalists. So this is a very interesting group, but one of the more interesting arguments, especially from an apologetic standpoint, that I hear brought up a lot is the principle called agency. And I hear it used a lot, and sometimes I hear it used a lot in a varying different degrees of application. And sometimes it leaves me a little bit confused because it's not always used to the same degree. And so I said, well, I guess before I engage in more conversations, I want to do a lot of bottom up conversation related to how agency should be understood, how it should be underapplied, and better yet, how was it understood maybe in most ancient biblical context? And I think that will probably be a good place to start. And so, for those who are watching on YouTube, I would like to ask you to please take this time to share, rate, and subscribe. Let somebody know that we have an Apostolic Pentecostal podcast going on. And I would most certainly appreciate your support as we hope to grow this ministry that is endeavoring to reach the whole gospel to the whole world with the saving message of Jesus Christ, because we are definitely in a world that needs to know that Jesus is alive. He is not just simply willing to save, that he is saving. He is willing to do exactly what you need him to do, that he is able, willing, and desiring all men to come to the knowledge of the truth. And if you are interested, and I've meant to mention this the other night, I think someone said there's a problem with my audio. Let me know if you're streaming on YouTube, if it's too strong. Let me see if I can pull it down a little bit. I don't want it too strong for those who are listening on other mediums. I think it's the Tattered Podcast, and see if this is a little bit better for you. You see if that's working out a little bit better for you. We definitely want the Lord to increase in this work of salvation that he is doing. But let me see here as I'm going to my YouTube channel here, moving to my brand, going to remove this piece here. I'm going to hide this. I'm going to be continuing to use my Speechify tool as we're going to be reading this wonderful scholastic article, because one of the things I want to do is that when you're discussing concepts, I don't like to get academic pieces that are straw man. I like to get things that have academic integrity, that are the better representations of positions. And on the JRST website, which is academically verified website, and I will have interactions a little bit later. I'm going to do the reading, but I can let you up right quick and see if you have someone want to add something to it. I see that's Karath. See if you want to come up. Think somebody want to ask a question or something before we get started, unless that was an accident to come up. I'm not sure. But yeah, the article we have is entitled The Jewish Law of Agency. And the author's name is entitled Israel Herbert Levinthal. And the source is the Jewish Quarterly Review from October 1922, new series volume 13, number 2, October 1922. And this can be found on pages 117 through pages 191. The publisher is the University of Pennsylvania Press. And of course, I have enclosed the link for those who would like the details, that you can click on it and find it and read it for yourself. But for those who are just simply listening, this will be where the information can be found. So I will be using Speechify to help us in our endeavor tonight. And we will be making our commentary on it as we go. But the goal tonight isn't to debate it, but to simply get an understanding from this author's view, and to, of course, build our understanding foundationally from how this view is developed. So let's begin tonight.
The Jewish Law of Agency by Israel Herbert Levinthal, Brooklyn, N.Y. Introduction. The Jewish people have been credited by the world with having contributed more than any other people in the domain of religion and religious morality. Even the most stubborn of our opponents admit that religion would not have been the force and the power in civilization that it is were it not for the Jew. Few, however, know how much the Jew has contributed to other fields in the realm of human progress. To Rome is given unstinted praise for her legal system and for her influence upon juristic development. No textbook on any legal topic fails to pay homage to Rome for her contribution in the field of law. That she deserves most of this praise, no one will doubt. But that the Jew is deserving of more credit than he receives for his contribution in the field of law is realized by only a few. When one delves in the pages of the Talmud and glimpses in the works of the later rabbis, he marvels at the fine legal insight possessed by these ancient sages, and at times he would almost be led to believe that he is studying the laws of some modern and highly developed code. Nay, more, he would begin to ask himself, is it possible that this ancient collection of laws, that are so in consonance with the modern juristic spirit, should have had no influence upon the systems of law that rule the peoples of today? He would then, undoubtedly, come to the conclusion reached by President Woodrow Wilson when he said, in his treatise on the state, it would be a mistake, however. 118 The Jewish Quarterly Review. To ascribe to Roman legal conceptions an undivided SWA over the development of law and institutions during Middle Ages. The Teuton came under the influence of Rome only, but also of Christianity, and through Church there entered into Europe a potent leaven of Jew thought. The laws of Moses as well as the laws of Rome contributed suggestion and impulse to the men and institutions which were to prepare the modern world, and if could but have the eyes to see the subtle elements of those which constitute the gross substance of our present both as regards the sphere of private life, and as regard the action of the state, we should easily discover how besides religion we owe to the Jew. It is true that all ancient peoples have developed certain systems of law, and in fact many are the laws that are found to be similar among them. The eminent scholar in faith of the study of comparative law, Joseph Kohler, has gone so far as to say, the more we proceed in our study of humanity the clearer and the more evident it becomes to us that the whole human family, despite national peculiarities, are actuated not only by similar instincts and desires, but especially in law and in the development of public institutions. They show the influence of similar cultural forces. 2. But the more we study ancient law, the more we come to the conclusion that in no other system has law so much in common with the modern development, and nowhere are the true grounds and reasons of law so well declared as in the jurisprudence of the Jew. The study of Jewish law is important not only because of its essentially modern conception of human relationship, but also because by means of this study we get the clearest insight into the unconquerable spirit of the Section 2 Jewish people. He who would endeavor to comprehend and to appreciate the national life of the Jew, he who wanted to understand the spirit which helped to create his divine literature, must first become acquainted with the foundation, the groundwork upon which such a life was reared. This foundation and groundwork is not, as in the case of other peoples, to be found in their land, but in the law of Israel. 3. The distinctiveness of Jewish law. What impresses the student of Jewish law, even more than its similarity to the latest modern systems, is the humane spirit that permeates the entire body of the law. To do justice is the very purpose of all law, but justice itself, if carried to extremes, may sometimes result in injustice. Jewish law endeavors to be humane as well as just, and, therefore, takes cognizance of the human element in all human relationship. And it is this humane element that strikes a distinctive note and makes its strongest appeal even to the non-Jewish student. 4. Perhaps this is due to the fact that among the Jews the distinction between religious and secular law was not known. 5. The division by scholars of the Mosaic and rabbinic legislation into moral, ritual, and legal laws is wholly arbitrary. 6. In fact, the religious element plays a very important role in all ancient nature peoples and permeates every phase of their life. Law and religion are to them one and the same thing. Indeed, law is but one of the many forms by means of which their religious ideas are put into effect. 7. In the case of the Jew, however, his religion not only influenced his law, but permeated its very structure. His law was to impart and parcel of his religion, and Kohler grasped the force of this truth when, eulogizing Jewish law, he exclaims, Das Recht de alten Israel, es war ein Sack. Rau Rectum H. 610.8. The basis and development of Jewish law. At the outset, we must endeavor to understand the basis and the development of all Jewish law. Each and every law must be based upon, and find its source in, Holy Writ, or at least in an oral tradition bearing upon an interpretation of the biblical word or phrase. In the discussion of every law, you will always find the expression, upon what scriptural verse is it based? The Talmud is not a code formulated by a legislative body, nor does it, of its own volition, decree the law. It derives its authority solely from the scriptures, and the interpretation of the biblical words is its principal function. 9. That does not mean that all Jewish laws are to be found in the Bible. Post-biblical Jewish law most certainly went beyond scripture. New provisions had to be created to meet new conditions which could not have been foreseen. The scribes, and later, the rabbis, for political, national, and natural reasons, endeavored to create, by legal fictions, by equity, and by legislation, a hedge around the Torah, a chain of tradition. Though in theory the legal canon was closed forever, it did not in fact prevent the Jews from interpreting and developing their laws and precepts with life-giving freedom. But this interpretation and development was always centered about the Bible. Point 10. 8J. Kohler, especially is this true in the case of the civil law. The development here presents a remarkable contrast to that of the criminal law. While the latter retained all through the course of existence its Mosaic character, the former was practically a Talmudic edifice reared on Mosaic principles. But this contrast is explained easily enough. Criminal and capital laws are closely connected with the existence of an independent state. Civil laws enjoy a certain independence of political conditions. Autonomy itself offers an ample field for the growth of the latter. And as the Jews continued to enjoy their autonomy for a long time in Palestine, and especially in Babylon, after their right to practice their criminal law was taken from them, their civil system continued to develop after the destruction of the state, with ever-increasing vigor. In fact, it reached its culmination in Babylon. Point 1L. The Bible itself contains comparatively very few civil laws, and even those mentioned are not stated explicitly but casually. Contracts and obligations are hardly touched upon. The only laws sufficiently expounded are those of damages, guardians, and inheritance. It is evident that the civil laws mentioned in the Pentateuch were adjusted to an agricultural community, living in the small circle of its family possessions, without practicing much commerce or industry. As soon as the family circles were broken and intercourse and commerce spread, the few prescribed laws proved insufficient and a system of civil laws had to be constructed. It is possible that under these conditions, Jewish civil law was somewhat influenced by the system of more commercial nations, such as the baby dash. And it is for the same reason that one may note that Philo in his discussion of Jewish law is more in conformity with Lonians, with whom they came in contact. During the Second Temple, the civil law kept on developing according to the life, conditions, usages, and rules of conduct of the age, adapting and modifying usages of other legal systems. Most likely the Roman. Point 12, as already stated, the Jews practiced their own civil law even after the loss of their sovereignty, and it continued its development, reaching the height of its glory in the Babylonian period. In later years, attempts were made to collect in systematic fashion the manifold legal decisions scattered through out the pages of the Talmud. One of the first and foremost of these codes were digests of the law was the Mishneh Torah, or the Yad HaHazaka, of Maimonides L3, in which the author strives to state the law as the Talmud has it, and in which he also mentions certain cases which show the later development of the law. The next great work of systematizing Talmudic law is the Tur, a code of law, written about 1340 by Jacob ben Asher. Point 14 finally must be mentioned. The Shulchan Aruch of Joseph Caro, 15, which again endeavors to give a clear and concise statement of Jewish law. The law in these codes, however, must be studied carefully in order to know which may be traced to Talmudic sources. As in the interim between the Talmud and the Shulchan Aruch, Jewish law continued to grow and to develop. Difficulty in studying Talmudic law. When we compare the Jewish law of the Talmud with the Roman law, one thing must be said to the advantage of the latter. Roman law is a model of system and harangue. 12 CFM Waxman, Civil and Criminal Procedure of Jewish Courts, Seminar Annual, 1914, page 263. For argument, it was a guide for the actual life of its citizen. General principles of law, only, are given, and it was the function of the judge to decide the detailed case before upon these stated principles. In the Talmud, however, the reverse is the truth. System and arrangement are lacking. The Talmud is not a code of general legal principles, but rather a compilation of discussions of detailed and specific cases of law. Furthermore, it must be remembered that the Talmud is not a legal work alone, but comprises many other subjects. The legal subjects treated therein are, therefore, not systematized and arranged in certain parts, but scattered throughout the many volumes and their pages. The same subject may often be discussed in various sections and under different headings. Point 16. It is because of this difficulty that so few attempts have been made to treat the legal topics of the Talmud, and that many of those which have been made contain conclusions and deductions that are erroneous and fallacious. It must, furthermore, be remembered that most of those who hitherto wrote on the law of the Talmud were theologians rather than jurists, and theologians not altogether free from prejudice and bias. Point 17. The day has come when this interesting branch of study should engross the attention not only of theologians but of lawyers and jurists as well. especially those students who realize the importance of the study of comparative jurisprudence. They will then find that what was said by Hale, the distinguished English jurist, with reference to Roman law might equally well be said of Jewish law. He set himself much, says Bishop Burnet, his biographer, to the study of the Roman law, and though he liked the way of judicature in England, yet he often said that the true grounds and reasons of law were so well delivered in the digests, that a man could never understand law as a science so well as by seeking it there, and lamented much that it was so little studied in England. 18. The law of agency. Meaning and scope of subject. Agency in its broader sense includes every which one person acts for or represents an authority. This is not the sense in which it is in this paper. To study the Jewish law of agency inquiry would be too broad in its scope, and while studies in guardianship, bailments, letting and here in partnership, wherever one may act in the in another without being technically his agent. 19 shall limit ourselves to the more restricted sense in which the term is used in the Anglo-American law, and shall deal with the relations established when a person known as the agent is authorized to represent and act for another, known as the principal, and does so represent and act for him, thereby legally binding the principal in his connection with a third person, and also with the relations established when a representative is vested with authority to perform operative or mechanical duties for his principal, not intend to create any new legal relations between him and third persons, but simply acting for his benefit or interests alone. 20 In other words, we shall deal with the subject as understood in the
I was going to make my first break there. That part there kind of caught me there. I was noticing as it was talking, it gave a pretty good definition of purpose as I was reading that, because when I sometimes talk to some of course, my friends who really use the principle of agency, one of the biggest challenges I personally have is getting a concrete definition of the purpose of agency. And as the paper previously stated, is that many of these I guess hard definitions of Jewish law are not specifically spelled out in scripture, in that many of them were developed, I guess, post scripture for practical reasons. But the author, as he goes on to say in this article, and I see my friend Faithful there, good to see you. It says, here we shall limit ourselves to the more restricted sense in which the term is used in the Anglo-American law. And I think that's usually the sense that we usually hear it, even in the apologetic sense, and shall deal with the relations established when a person shall be known as the agent is authorized to represent and act for another, known as the principal, and does so represent and act for him, thereby legally binding the principal in his connection with a third person, and also with the relations established when a representative is vested with authority to perform operative or mechanical duties for his principal, not intending to create any new legal relations between him and third persons. Now, that's an interesting caveat, because sometimes I was asking, like, well, what are the, like, when they say, well, is an agency? Sometimes I ask, okay, well, what are the limitations of agency? Well, they're doing agency. Like, well, can the agent create other agents? Like, like, well, what are the whole gambits of agency? Like, how do I know when agency they're not supposed to be used, if you will? In other words, we shall deal with the subject as understood in modern law under the headings of principal and agent and master servant. So I guess if we're dealing with agency in apologetic sense, I guess if I'm talking to someone that is appealing to it as in scripture, I guess if you know that this is something that a person is going to appeal to, I guess we have to get some ground definitions of how they're going to be using or appealing to it, because what I'm seeing, it's going to be an infinite merry-go-round of agency, which it's going to just make the conversation just utterly fruitful, which I just think it just makes the conversation just nonsensical at the end of the day, if you will. And I'll continue there, but just how the author just grounded what he meant. I mean, it just brought so much clarity. But how often do we get that when we're having, I guess, a person who just, I call it agency abuse, if you will.
Modern law under the headings of principal and agent and master and servant. 18. The person who serves a principal in this relation is agent, known in Jewish law as nl. Shalua, or en shalia, one who is sent. 21. The person who sends or authorizes the shalia to represent him is usually term lni, the mishalia, or noiv sholia, one who causes to sent or one who sends. The relation created between the two is known as nln asterisk or shelihat, or agency. Distinction between agency and other legal relations. It is sometimes quite difficult to determine warehouse. A certain contract creates the ordinary relation of an agent or a special relation covered by some of branches of the law, as, for instance, the relation of ship. A partner is also an agent, but his agency, special and peculiar character. Maimonides, 4. Felt the closeness of the legal relationship to such a that he joins the laws of both of these subjects on heading Hilket Sheliahin Wishatafin. Point 22. As in the Law 23, so also in the Jewish, it is safe to say that it a question of construction upon the whole agreement. The intention of the parties will be the control in 21. I am in agency belongs to commercial age. Accepting our definition of agency, it will at once be seen that it belongs to a condition of society in which commercial transactions are highly developed. A non-commercial society, while it might have much use for servant, would have little need of agents, empowered to represent the principal in business dealings with third persons. Is for that reason that in the English common law, agenc as a separate subject is a matter of late development. In fact, the very title agency is of modern origin. Blackstone scarcely refers to it. The law of principa and agent, says one of Blackstone's most learned editors, Professor Hammond, is derived from the canon law, and how only been introduced in the common law in recent times. Principal and agent does not occur in Viner's abridgment or those preceding it, and it is only at the end of the 18th century that we find it beginning to appear as a separate title, as yet of very limited applications. Point 25. The index of Reeve's History of English Law contains no reference either to agency or to principal and agent. So, too, Sir Hen Main has no reference to this subject in his Ancient Law. That the early Roman law was destitute of the mode notion of agency is admitted by Mr. Hunter, who attempts to explain it with the statement, "It must be remembered that the absence of agency characterizes Eve department of the ancient law."
Wow. Now, wait a minute. I just caught something there that I'm going to have to wait a minute to chew on that for a minute, because I never even thought about that. And of course, I just pulled this article up on an academic EDU website. I saw it, it's written by a Jewish gentleman from 1922. And I said, man, this would be a good room to have. But if I'm understanding him correctly, which I'm going to have to go back and, review his assertions, that from what he's saying, that this concept of the principal and the sender, that this is actually a modern concept as we have it, that this concept is not ancient. And definitely, if they didn't have this in ancient Rome, I wonder, would I be safe to say that this would not have been a concept at least as well developed as it's being presented in an apologetic sense in the ancient world? And again, I'm speculating. I'm not taking a hardline stance. I'm thinking creatively, because the way that, at least that I'm used to hearing it weaponized against people who hold the deity of Christ position, is very much in a full westernized legal sense. The principle and the sender, that it's a very westernized, legalistic, developed type sense. But if this assertion is correct, there's no way in the world they could have been thinking in that type of sense of agency, let alone that the phraseology wasn't even used. But again, I try not to hold people to that. The phraseology not being there is the concept there. But that's very interesting. That's very interesting. But I guess I have my work cut out for me.
26, 24 Meckham, 10, 25 Hammonds. But Mr. Hunter, in this sweeping assertion, fails to note the one important exception, the Jewish law. And only does Maimonides know and deal with the specific term of Shelihut, agency, but even the rabbis of Talmud frequently speak of the Shaliah, the agent, and the Meshaliah or Sholiah, the principal, and show the complete understanding of the importance of this leg relationship. Classification of agents. Some modern jurists make a distinction between the relation of principal and agent and that of master and servant. Point 27. It is often said that the distinction lies in the fact that an agent is vested with discretion, while a servant is not. Point 28. According to Huffcut, 29. The difference between the agent and the servant is not that one has discretion and the other has not, but depends upon whether his authority is to do an act which results in a contractual obligation with a third party or not. In the first instance he is an agent, in the second he is the servant. Point 30. If we would apply Huffcut's theory to Jewish law, a man sent by the principal to deliver to his wife a get, a bill of divorce, would be an agent. If, however, the man was vested with authority to drive a horse to a designated place, he would be a servant. But it must be noted that Jewish law makes no such distinction. In both of the above instances, Jewish law would designate the party. 27. So the Roman law speaks of procurator, vested with authority as the Shalia, agent. Point 31. And it is interesting to note that while modern textbooks do speak of agent and servant, legal writers of renown minimize the distinction, and evidently agree with the Jewish law that in legal essence there is no difference between the relation of master and servant and that of principal and agent. The terms, they say, are fundamentally interchangeable and the distinction between them evidential only. Point 32. Modern writers, in treating the theme of agency, also make a distinction between general agents and special agents, the first applying when the agent has authority to act for his principal in all matters, the second applying when the agent is authorized to act for his principal only in a single, specific transaction. Jewish law makes no such distinction, and again it is worth noting that the more advanced authorities are in agreement with the Jewish view. Point 33. Jewish law makes only the following distinctions, or rather classifications, in the field of agency. It speaks of the 9 sarzer, literally, a broker or middleman, but which is defined by Maimonides and the later codes as a shaliaj or agent, who receives pay for his labors in the principal's behalf. Point 34. The Ba 35 makes a very striking distinction between the word sarzer as used by Maimonides in connection with agency and the word nd1d sarzer, also 30, used by him in his discussion of sales. Point 36. The former suggests, means agent, the latter means a broker, a midman or commissioner. 37. Called in the Talmud and Ars Afsara, broker. Point 38. The sarzer is subject to the same L as an ordinary purchaser, and not as the sarzer, or H. Hence, if a principal said to his sarzer or agent, "Selleth me my pin for $100, and he sold it for $200, the extra money received would belong to the principal. 39. Bu a sarzer were told to sell for $100, and the article brought more, the surplus would belong to the broker. Point 40. From the definition of sarzer, as given by Maimonides, that he is the paid agent, we would infer that the general term shalia agent, as used in the Jewish law, refers to a gratuitous agent alone. Point 41. While there is this distinction between the sarzer and the shalia, viz., that the former is a paid agent and the latter is a gratuitous agent, the legal consequence of their relation to the principal and to the third party is the same, with the one exception, the question of the agent's liability to the principal for loss or damages suffered by him. Point 42. I believe that it would be more correct to say that the term shalia is the general or inclusive term of agency, and is used when we speak of rules applying both to the paid and to the gratuitous ones, while the term sarzer is used when we speak of the rules applying to the third paid agent alone. In their legal effect, there is absolutely no difference, with the exception just noted. Point 43. There is a third type of agency spoken of in Jewish law, Nini W. Harshua. 44. Literally, an authorization, ity or power of attorney, and refers mostly to cases where the agent has a written power of attorney and I now t represent his principal in court, bringing an action in his behalf to recover money, land or goods that belong to him. Point 45. While Harshava is used mostly in connection with court action, it does not limit itself to that, and may be used a written authority in ordinary agency to collect from the third party an article belonging to, or a debt due to the principal. Point 46. The main difference between Harsha and Shalahut, then, is this, that the latter would refer to a contracts of agency, while the former would be used onl to collect a debt or in an action to secure a certain article from a bailee or trustee belonging to the principal. There is also a practical difference between ordinary sheli.ute and harsha. It will be shown later that the death of the principal revokes at once all agency. Point 47. Now suppose Ru then sends Simeon to collect from Levi a debt due him, or 43. Rabbanu Jeraham distinctly take from him an article of his held by Levi. Suppose further that before Simeon performs his mission, Reuben dies. Levi, not knowing of Reuben's death, pays the money to Simeon. If Simeon would then lose the money, Levi would be responsible to Reuben's heirs for the amount. If, however, Reuben, in the same case, gives Simeon a harsha, Levi could pay him the money, even after Reuben's death, and Simeon would assume all responsibility. The harsha, in legal effect, transfers or assigns the claim itself to the agent, and hence the death of the principal has no effect. Point 48. Hence, the third party, if he so desired, has a right to refuse to acknowledge an ordinary agent sent to collect from him a debt, while he must recognize the mersh. Point 49. It is interesting to review, briefly, the historical development of harsha. Point 50. From the Talmud and Maimonides it can be seen that its use was greatly restricted. Originally, it was not to be used in the case of a debt or in the case where an article was sought from a bailee, the possession or title of which was denied by him. Point 51. It was not given in the case of a debt, even where there was documentary evidence of the loan, on the principle that the identical money loaned could not be traced, and D31Y, NL3V, TRPD2RTR 1 foot. The GNM, however, saw the hardships caused by this rule in that it discouraged loans, and ruled that in th case of loans, where there was written evidence of the deb harsha, could be given, even where the debt was denied, but it was still not allowed in the case of debts arising by parole. It was only later, with the development of trade and business, that the rabbis allowed harsha to be used in all Cases in debts arising from verbal as well as written contracts, and in disputed cases of bailment as well as where possession was admitted. 54. It is interesting to note that the rabbis limit the mersfeh to represent the plaintiff only. 55. The principal reason for compelling the defendant to appear in person seems to have been the feeling that if he were obliged to face the plaintiff in open court, there would be slighter probability of false plea or concealment of the truth on his part. 56. Besides, the plaintiff is supposed to have positive right to tangible things, whether property or money, and such rights can be transferred to an agent by the normal act of kinyan, while the defendant has only verbal answers, which cannot be transferred, so that his representative is only a lawyer, and such an office did not find favor in Jewish law. 57. The only case, it appears, known to the Talmudists in which it was assumed that an attorney might be permitted to appear for the defendant, was one in which the high priest was sued. There, however, he was not called the mersh, but n plus element lar 58, revros aptos. Principle upon which agency is founded. The theory of agency is founded upon the oft-declared principle mini dw ln ilm 59, a man's agent is like himself. Which means that one who acts through an agent is in law regarded as if he does the act himself, and also that what a man may do in person he may also, in most instances, do through a representative. Jewish law carries this principle to its logical conclusion, and shows how far more advanced and more modern it is than the law of Rome. While the latter declares that no acquisition of property could be made by a free person for the benefit of another. 60. The following passages cited from the Tur will show to what length the principle was followed. By the former, if Reuben says to Simeon, TDP1RT, buy something for me, and Simeon buys NNNDD, without stating whether he purchases it for himself or for someone else, then, in that case, Reuben acquires possession NAL 1 LEN from the very moment of delivery. 61. And even if Simeon purchases the article with his own money, he can not, once the article has been delivered to him, claim that he meant to purchase it for himself. It is Reuben who acquires possession and the article belongs to him. It is he who can sue and be sued on the transaction and not the agent. 62. Person should another, and a still more striking case will prove how logically they clung to the legal fiction that a person's agent is, in legal effect, the person himself. If Reuben says to Simeon, sell for me this article for $4, Simeon succeeds in getting $6 for the article. To whom does this extra profit belong? Unhesitatingly, the rabbis decide that it belongs to Reuben, because as soon as Simeon received the money in payment, it were as if Reuben himself had received it with his own hand. For NRLYIN01P, 1MP, the agent stands, but in the place of the principal. 63. Whence the doctrine is derived. As was said above, 64. Rabbinic law was based upon scriptures. Talmudical law hardly knew the meaning direct legislation, but concerned itself with the development of the law of the Torah. Agency had become a niches in the developed life of the community. It was important therefore to find the doctrine of agency in the Pentateuch, and so the rabbis seriously discussed the question, MNL 15 equals, whence is the doctrine of agency derived? 65. Up what scriptural word or phrase is it based? And it is worthwhile to record here, in brief, their ingenious, but all logical, interpretation. We must derive it, says the Talmud, from the word, NMI, and he sendeth her out, used in connection with the husband's giving his wife bill of divorce. Scripture might have said, WTNZL, and he giveth her a divorce, but expressly used the word NNI%L, the same root as in the term NS, to teach us that the husband can appoint an agent to deliver the bill delivered of divorce unto his wife, and hence, that a man may appoint an agent to act in his behalf. The rabbis then ask, Scripture could have said runit, why does it say, NMBR, to teach us that the wife, though she is only a passive character in the matter, the husband alone being the active party in divorce proceedings, can likewise appoint an agent to receive her bill of divorce? From the fact that the Bible, in the same context, 67 repeats the word NNRMTV, we may deduce the rule that an agent may appoint a subagent. 68. The rabbis then want to know whence agency may be derived in the case of marriage, for according to Jewish law, a man may marry, i.e., become betrothed LDRMN, through an agent. 69. We cannot make an analogy from the case of divorce, because the latter suggests a distinct difference, inasmuch as it is a case of NNNDY, compulsion. The wife's consent is not necessary in the matter of divorce. We would therefore say that here agency applies, but in the case of marriage it does not. In answer to this, the rabbis refer to the two words in the same verse 70 N1 FCW and N she departeth and she becometh another man's wife, and make a comparison between the two. Just as in the case of her departing, i.e. divorce, an agent may be created to represent the principal, so also in the case when she becometh the man's wife, i.e. marriage, an agent also may be appointed to represent him. The rabbis then ask, we learned that in the case of NNN, the gift offerings that were to be set aside for the priest, an agent may set aside the gift for his principal. Whence do we Derive that agency is to be allowed here? We cannot infer this from the case of divorce, because the latter is an instance of a secular matter. Here, we would say agency is permissible, but in the case of teruma, which is a sacred matter, we would say that agency cannot apply. We derive the law, answers the Talmud, from the seemingly superfluous word it also in the verse, dnt ip, thus ye also shall set apart 71, and from this m3 also we infer that agency applies here too. The rabbis then produce another instance, where agency is recognized, viz. the case of NN 1 ip, the offering of the paschal lamb. Again, they note that we cannot infer it from divorce, because that is a secular matter, and here is mtwrp, matter belonging to the realm of sanctity. It is deduced, they tell us, from the scriptural verse referring to the slaying of the paschal lamb nr, w, nri 7np, inl, linru, and the whole congregation of Israel shall kill it. 72. This verse does not mean, says Joshua b. Korah, that the entire congregation had to kill it, one only did the slaying, but the Bible regards the act as done by, and in behalf of, the entire congregation, and thus we learn from Scripture that the act of the agent is the act of his principle. The Talmud proceeds in this manner, endeavoring to infer one case from the other, but comes to the conclusion that each case possesses some distinctive feature and must therefore find its own source in the Bible. 73. Formation of the relation of principle and agent. There are various ways in which the legal relation of 7. Principal and agent may be created, 1. by mutual agreement, 2. by estoppel, and 3. by subsequent ratification. 1. By mutual agreement. The relation of agency in Jewish law, as in modern law, is created immediately upon the authorization of the agent by the principal to do for him a certain act, and the acceptance of this authorization or appointment by the agent, either by express words or by proceeding upon the performance of the act so authorized. 75. 2. By estoppel. The modern doctrine of estoppel may also be noted. In the Jewish law of agency, the principal has the power to revoke his agent's authority to act in his behalf at any time he may so deem fit. 76. But suppose a held out B to be his agent to collect a certain debt due him from C, and before B collected the debt, or revoked his agency. Suppose, furthermore, C, not knowing of the revocation, paid the debt to B, then A has no further claim upon C. 77 is revocation, insofar as it related to C, can have no effect, and A is stopped from proving it because C can claim that, not having knowledge to the contrary, he had the right to rely upon the presumption that the principal had not revoked his authority. 78. The theory of estoppel is based upon the desire to do justice, so that where one of two parties must suffer, he who at first held out the agent as his and thus led others to believe that he was acting, with full authority, in his principal's behalf should be the one to suffer rather than the party who was absolutely innocent. It is no surprise, then, that the same theory shall be applied in Jewish law. And so we note the case that where Reuben gives Simeon a power of attorney to sue Levi for a debt due him, and Levi goes to court with Simeon, but judgment is given in Levi's favor, Reuben cannot now come and claim that he had revoked Simeon's power to represent him before the suit began, and that, therefore, the judgment should be set aside. 79. As another example of agency by estoppel may be noted the MPN decree of our Gamaliel the elder, that a husband who sends a bill of divorce by an agent should not revoke it, unless knowledge of revocation is given either to wife or to agent, the reason for such decree being LYNPLPN 3 in public policy. 80. The clearest case of the formation of the relation by estoppel is the following: when N, in the presence of B, says to C, I am B's agent, and B remains silent, B will afterwards be estopped from denying A's agency. 81. 3. By ratification. The English common law has recognized the theory of agency by ratification. Briefly, the rule may be stated thus: where one person, whether no agent at all or an agent exceeding his authority, does an act as agent in the name of or on behalf of another, the person in whose name or on whose behalf the act was done may ratify the act and thereby give to it the same legal effect as if the one doing it had been in fact an agent, or, being an agent for some purposes, had been in fact authorized to do the act in question. 82. Does the Jewish law of agency recognize this rule? 83. While the rabbis do not give concrete case bearing upon this phase of the subject, it can be shown that the principle was not foreign to them. In fact, there is a doctrine frequently stated in rabbinic law which recognizes the fundamental principle upon which the theory of ratification is based. R3 and TIWDRP, RT, you may obtain a privilege or benefit in behalf of a person in his absence. 84. Accepting this principle, it would appear that where A purchased a piece of land in behalf of and in the name of B, B not having appointed A as his agent at all, yet when B learns of the purchase he may ratify the act, that this ratification will relate back and will be equivalent to a prior authority. B will be able to sue and be sued upon the transaction. The important element in the principle of ratification is that the would-be agent must do the act in the name of and in behalf of the person he desires to represent. If, however, he makes the contract or deal in his own name, not purporting to act on behalf of a principal, but having a secret intention to act, though without authority, for a principal, the contract so made cannot be ratified by the undisclosed principal. 85 It is this element especially that the rabbis recognize and discuss. The Tur 86 gives the following case, which may be in point, desiring to prove that by the agent's acquisition of property in behalf of the principal, when he was told by the principal to purchase it for him, the property already belongs to the principal, and the agent cannot afterwards claim that he made a mistake and had meant to purchase it for himself. 87 The Tur makes this additional significant assertion. If the agent purchases the article in the name of Reuben, then, even if he gives his own money for the purchase, he cannot later claim that he purchased the article himself, once N.R.O. the act of transference had taken P and he accepted the article in the name of Reuben. It is true that the Tur, in making this statement, meant it to apply to the former case where the agent was appointed by his principal. Nevertheless, I believe that from the wording of this statement of the law, especially the emphasis upon the condition that even if he used his own private money as the purchase price, the rabbis would follow the theory of ratification. A still clearer case in point is the following, which even goes beyond the modern accepted theory of ratification, where the notion is that the third party does not know that the agent has no authority to act. If A comes to sue C for a debt the latter owes to B, without having the NRWNN Harshoa or power of attorney, the proof of his agency, without which he cannot force C to go to court. 88 Then even though he is at present not B's agent at all, nevertheless if he offers to guarantee that he will later get the Harshoa or authorization from B, C must recognize him and answer him in court. For we accept the principle LZR 13 DHWDKIT, we may obtain a benefit in behalf of a person in his absence. 89 The following case must also be mentioned, for here the principle seems to be accepted to the fullest extent. If Reuben purchases a piece of land from Simeon in behalf of Levi, whose agent he claims to be, and the deed is written in Levi's name, Reuben cannot afterward say, I purchased it for myself and want you to write another deed in my name. 90 The rabbis, it is true, base their ruling upon the theory that the seller ought not to be troubled to write an extra deed, but I believe that the underlying principle is after all the desire to benefit a person, in whose behalf another undertook to act. And Israel's, in his gloss to this passage, expressly says, even though Levi never authorized or appointed Reuben to purchase the land for him, if Reuben did purchase the land in Levi's name, and paid for it with money that belonged to Levi, then the sale cannot be rescinded. 9L Were it not for this extra stipulation which the glossator required, viz. that the money should belong to the principal in whose behalf the act was done, this statement would coincide in every particular with the modern doctrine. That the rabbis accepted the principle of ratification can be seen also from their statement of the reason for the law, that if one finds an article in the street and takes possession of it in the name of another, it immediately belongs to the one in whose name and in whose behalf possession was taken. There the rabbis give as their reason that Ninri Ydnirtr, when he takes possession in behalf of the other he makes himself an agent for him, and the law of possession that is applied here is the law that applies to agency. 92 A case where the principle of ratification is fully recognized is the following, where B, who is not appointed agent, learns from a hint that A would like to marry C and B performs the kiddushin in behalf of A, C then becomes lawfully the wife of A. 93 The theory of ratification is also recognized by the Talmud in the case when one voluntarily takes possession of goods from a debtor in behalf of a creditor, though he was not requested by the creditor to do so, when 7 DD1 IR I1 P 2 inches. The rabbis allow such action where there is only one creditor, but refuse to sanction it where there are a number of creditors, not because they dispute the principle of ratification, but because of public policy, the injury that will thus accrue to the others. 90 For the clearest case and the most direct reference for ratification is the follow ing cited in the Shulchan Aruch, where A sells real or personal property and B purchases and takes possession of the property where the article in behalf of C being ignorant of the transaction, it is in C's power to ratify the sale or not. If he ratifies it, the article belongs to him, if not the sale is nullified and the article belongs once more to A. 95. There is, however, one important distinction between the theory of ratification as understood by the rabbis and as understood in the law today. The latter applies the rule not only where it works to the benefit of the principal but also to his injury or disadvantage, and thus permits him even to ratify the tort of an agent. Jewish law clearly limits the theory to cases where it works to the principal's benefit only, the principal being 1 WRAK-NL where Z3M-equals N71 we may benefit a person in his absence, but cannot add a burden upon him. 96 Says the Bir Hagola, in commenting upon the above rule of law enunciated by R. Israel's 97 that if the court sees that the agency will not benefit the party in behalf of whom he acts, then the agent will not be permitted to act for him. Even in agency by appointment, the principal can always say to his agent, NMLY 5-1 North-Northwest WP and 7 I have appointed you to benefit me, not to injure me. In this case, where he has not even appointed him, he could surely make this claim. The Nimyut Yosef 98 expressly states, in speaking of a woman who desires to ratify the act of a man who, without her authority, accepted in her behalf a bill of divorce. 94. Getting from her husband that she cannot do so, even though she wishes it, because a divorce, generally speaking, does not come under the category of benefits to the principal. Can the third person recede before ratification? Can the third person recede from the transaction after he finds out that the agent had no actual authority to act for his principal and the latter had not yet ratified the act? This is a disputed point in modern law. Point 99. According to Jewish law, it is clear that he could not, for applying the rule of Nernru dp drratia in Shelahat. A
And
shalia,
I'm going to
or sarzer, a
jump to
gratuitous or
this point,
form of appointment. A. In Shelahat. A shalia, or sarzer, a gratuitous or paid agent, may be appointed by oral communication alone. The appoint dash meant does not need P1P Kinyan, the special symbolical form of making an agreement binding, nor does it have to be in writing or in the presence of witnesses. Ioi. As my dash Monides puts it, witnesses can serve only where there is a conflict in testimony, to enable us to know who speaks the truth, or as the Talmud says 102 quoting Rab Ashi, witnesses are created only for liars, i.e. witnesses are not necessary to legalize the appointment of the agent, but only as a guard against faithless persons who might deny the transaction. 03. B. In Harshoah. The Harshoah, or power of attorney, is always in writing and is given in a particular way. It is accompanied by 1 pp Kinyan L0 for the special symbolical act of seizure, by means of which the mersh becomes invested with all the powers specifically defined in the instrument. Point 105. The HW 1NN to W Shitar Harshoah, or the written document, must 101 contain this formula, WH. PNMZTL, reti proceed, litigate, acquire, and possess for thyself 106 or words to that effect. If such words were not used, the defendant was not obliged to answer the attorney or to recognize him, and he could plead NKR, DRN33Y in caret, I have nothing to do with the .107. It must also conclude with the formula, RMNYNL1NYNDTI, I am responsible for that which thou wilt expend for me in the suit. .108. This latter provision, however, is for the benefit of the principal, or Mars He, as between him and the agent, to show that the latter, despite the formula, litigate in POS. Says for thyself, cannot lay claim to what he acquires, but remains an agent and must hand over the article to the principal. If, therefore, this latter formula, with reference to the expense, is omitted from the document, it remains valid, and the third party can have no objection to it. .109. We see, then, that the formula, go to law, win and get for thyself, does not actually transfer or assign the claim to the mersh, but it is only a legal fiction, used to give him the right to sue, just as if the claim had actually been assigned. An interesting case must here be noted. A has a jewel in the possession of B and comes to B to claim it. The latter answers that C came to him with a harshoah written by A, making claim for it, and he returned it to C, but C later loaned it back to him, and that therefore he is responsible to C alone, and is no longer responsible to A. The law decided that B must return th jewel to A, the rightful owner, for C, though he came via harshoah, was no more than A's agent, and had no legal right to loan it to anyone. 110. The rabbis, however, cling 106b, k, 70 to this legal fiction to the fullest extent. The document must show that the mersh will acquire for himself some part of the actual claim itself. And so they decree that if the harshoah states that the mersh acquires a third or a fourth part of the claim for himself, and not the inter-claim, even then the third party cannot say, I have nothing to do with thee, for a claim on a part gives you a right to make a claim on the whole. 111. But that is sufficient as long as the mersh has a right to acquire for himself an actual part of the claim. If, however, instead of a part in the claim, the harshoah gives to the mersh a definite sum, e.g. 100 dinars, for his services, even if this money is to be taken out of the money that is claimed, it will not be a valid harshoah. There must be an assigned legal claim to a definite part of the article claimed. 1.
And tonight I'm gonna stop that reading part for part 1, but I did want to open up the stage for anybody that want to come up. I'm gonna do a part 2 on it, but I have enclosed the article, of course, on the event link and definitely on the YouTube channel for those that are listening. But the reason, of course, I want to reiterate why I did it again. I wanted to open up the conversation so that we could kind of, I guess, get again more bearing on the background, because the more I begin to do research on the principle of agency, the more I find out that, man, this has a very rich historical basis within the Jewish world. Because I'll be honest, the first time I really started to come in contact with the principle, I guess, is more in the context of an apologetic objection to the deity of Christ. And I said, this is interesting. So the more I started to Google it and started to dig, and I'm not at the place of expertise in it that I would like to be, but like most things, I'm finding out that there's usually a lot more to it than what meets the eye. But I see different ones: Carlton, Faithful, Brightner, Elder Charles, Karath down there. If anybody would like to come up and engage on it, because as I'm engaging the subject right now, I'll be honest, I got more questions on it than I do answers. Not to say that I am accepting the way that it's weaponized against the deity of Christ, but as far as how it's applied and pretty much some of the assumptive stances that are taken to dismiss the deity of Christ. But I would love to hear anybody's thoughts on the subject if anybody had any time. One particular question I know I was thinking on the other day as I was talking or engaging with someone the other day. Oh, here we go. Yeah. Hey, how's it going, Faithful? How's everything going for you?
Hey, everything's been going fine. How are things going on your end, my friend?
Hey, going good, man. Hey, everything's flowing and moving as better than I deserve.
Yeah, to the topic of agency, I think if because I think you're referring to our conversations with some of our Unitarian friends on this app who invoke it as a polemic against the deity of Christ. So I've been aware of agency for a while now. Just because of the nature of these conversations, obviously I was forced to have to look into it, and you know, to me, the topic of agency need not negate the deity of Christ in any capacity. It's depending on our perspective, right? Because I think from either of our perspective, I don't think it's difficult to reconcile. I think that agency works in from either perspective, as since you and I, despite being on different ends of the Godhead conversation, we both affirm the hypostatic union of Christ, right? That he's fully
Yes,
God
sir.
and fully man. I think from your perspective, it could be reasonable to conclude that the agency is coming through his humanity, right? Whereas from my viewpoint, obviously, as a Trinitarian, I would say the agency is coming through the it would be the same logic, but it would just be the idea of agency from the second person. So at least from my viewpoint, there's a little bit more of a distinctive, but it need not negate the idea that propositionally, even if God were to inhabit human flesh, the human flesh is not divine, right? We don't believe that the human flesh was divine. We believe it was fully human, whereas the person inside of the human flesh is fully divine, right? So the flesh is fully human, the person fully divine. So it can be the case that the humanity serves as the agency in either instance. I'm sorry, I feel like I'm talking too much. I'll let you,
No,
chime in. But
that's
my
what you're saying.
thought.
What you're saying is actually that was actually one of my first thoughts on it. I think that's completely valid, and I would say that has always been, I guess, my original default to it. Because I always said, what would originally stop? Because I guess because originally I was thinking at first, because you hear that say, well, no, you have to be sent. Because I was working at first from the framework. Okay, does when you're using the principle of agency, does the sender have to be distinct? But one of the things of when you're talking with some Unitarians, they don't. I found with some at least, their understanding of the nature of God as far as being omnipresent is not always there. Uh, like I don't know, is in and that's I guess that's what makes it so difficult. Some at least, and maybe it's a misunderstanding on my part. I get the feeling that not all of them truly embrace that God is without spatial limitations. Uh, and sometimes that kind of throws a wrench in it where and maybe it's a misunderstanding of in some of the conversations I've had with some of them. But that's usually been my default that it's within his humanity. But someone said, no, the sender has to be like I have a spatial difference. But usually that's been my understanding of it. But like when you say like talking, I guess some of the spectrum of Unitarianism will know some will say, well, God cannot interact within this realm. It has to be through this agent. And so trying to, I guess, I don't know, it's kind of like almost kind of like a little Gnostic bent almost, where you can't have God interacting within this realm. So I've even talked to some that don't believe that God actually created the world. That anytime you see God referenced in the Old Testament, it wasn't anything divine. It was actually just this hyper form of agency that, just I was like, wow, that is the most blasphemous thing I ever heard.
Indeed. The thing is, they're going to give me 1 second. 1 second, Brand. Hold on. My apologies. I had to take care of something over here real quick. Yeah. So they're going to invoke the book of Hebrews, where Christ is called the apostle of God, right? So the Greek term apostolos, as you know, Brandon, is the equivalent of shalia, right? Because shalia literally just means sent one. Apostolos means sent one. So they're going to invoke that. That's not a problem for either of our respective perspectives. I don't see it as an issue, especially since we understand agency. Within its, I'm trying to find the right words here. If we understand agency to mean one who represents another from either of our perspectives, we can conclude that Jesus is in some sense being the agent of the Father. Now, from your perspective, obviously, the agency can be the humanity. I would say, from my perspective, it would not just be limited only to the humanity, but obviously in I think the role of sonship. But even in your perspective, I imagine sonship would also constitute agency.
Oh yeah.
I just don't see this being problematic, though. I don't think there's a problem there at all. At all, from either perspective.
And I think you have a point, because I have a tendency sometimes to overthink things, which I'm probably guilty of as being charged, because I guess some of my thought processes of, I guess, in really talking with them, because I'll be honest, it's as of the most Unitarians I've ever interacted with have been universal Unitarians, which they really don't care one way or the other. My interactions with them, they're like, great, believe what you want to believe. But I guess I'm just trying to, these textures, the Unitarians I've interacted with on Clubhouse, they have had some, you really can't really pin them down on some of their viewpoints. And so when we'll talk about some of these, I guess, different positions, I'm not used to some of them, like kind of like having some of these kind of weird variances of, like, I guess, like agreed upon things that you believe about the nature of God, as far as like believing that God is, he doesn't have spatial limitations. He doesn't have limitations on knowledge. And they have a variety of beliefs that I guess sometimes it's like you're spending more time, I guess, trying to define that you really can't address why these issues aren't a problem. Like talking even like far as instance of like trying to overcome, but I get what you're saying. I definitely agree conceptually. I don't think it's but what, and I guess in trying to talk to some, I'm trying to be very charitable, but I guess one of the issues that you're having with some of them, I guess it's talking certain portions. They don't, and not saying it's true of all of them, but some of them, they just don't believe certain parts of the scripture. And I'm trying to say that because I guess people can say that of me, but
or they reinterpret it. They have to reinterpret it in light of their Unitarianism.
Right. Yeah, which like we'll be talking like on a point where it clearly says God said, and again, I tell them certain instances where I clearly understand, like, okay, if it shows that in this instance, okay, where he used someone to do it, I'm not going to argue with you there. But to go from one point where it obviously says that the Lord said, and to assume that this must be the case in every instance, man, I'm like, don't you think that's a bit assumptive? Which it's I'm noticing it's a pretty aggressiveness, which what I am noticing that the Unitarian message is more about confessing what Jesus is not than confessing what Jesus is. And I was telling one sir, I said, you ever notice you talk more about what he isn't and what he can't do than what he can do? Like, you don't think that's odd?
Exactly. But just even exploring the idea of agency, right? Because they'll allow for angels to be agents, right? Where angels are representing God in the Old Testament. But angels are ontologically higher than human beings. They're not um, they're not humanity, yet they can serve as agents. So why does it seem like it's out of the realm of possibility for um, God to incarnate in a human body? Because there are even some instances of where one could say that angels even took on the form of human beings, right? For example, one such example that I could think of is Genesis 18, right? You have the example of the messengers, and at least two of the messengers are posited to be angelic beings, right? And the angelic beings have the form of human beings, right? It's interesting because Abraham even prepares meals for them. So it alludes to the possibility that angels, in some capacity, can even consume food. I mean, it does nothing for them, but they can consume it. Or at least, propositionally, they can be offered food, even if they don't eat the food. It's nevertheless that their form was such that Abraham felt, inspired enough to want to prepare all of them a meal. And so I wonder if that's possible for angelic beings. Why is it, from the Unitarian perspective, impossible for God to incarnate? That seems to be, if you think about it, right? You're willing to concede that it's possible for a supernatural being to come down, be offered food, walk amongst men, even be wrestled with in the case of Jacob and the angel. And regardless of how one takes the angel there, right? It's nevertheless the case that you have a spiritual being wrestled by a man. But somehow God Almighty incarnating seems implausible to them. And doesn't that seem a bit strange? Don't you find that
I
sort
agree.
of...
I agree. I was talking to one gentleman. He was this particular Indian. He was very charitable, and I asked. I said, he said, "Well, it's impossible. He can't do that." And I said, I understand this is your position, but what are the metaphysical constraints as to stopping God from doing that? It's like saying that the builder of a house is limited from entering the house that he builds. What would be the constrictions in place from stopping him from entering the house he builds? Or what law that we see from scripture that will prohibit him from doing that? It kind of it is kind of seems like you don't see this as some kind of philosophical presupposition that you're borrowing from outside of scripture that says that he cannot do this. And I struggle to see where that is borrowed from in the core of scripture, which that is and it kind of seems to me that it kind of like, well, you just don't understand. And I say, well, that's why I'm asking you, where are you building this definite line that he cannot enter or interact with this creation, that he's so high? And I had to repent because I got a little irritated. I said, well, you don't think that's kind of like an absentee father kind of deal going on, that he just Ubers everything. God never interacts with his creation. He doesn't have everything he does. He's always an angel. He never talks. He never, on the mountain is always an angel. I'm like, when the scripture clearly tells us that he is doing, now, of course, I'm not saying he never uses angels, but in every instance, I mean, it seems like these are a lot of assumptions that are convenient for your theology.
Exactly, I agree. And from the Unitarian perspective, I guess, because I held to the Unitarian perspective before I submitted the knee to Jesus truly, I could never reconcile when God appears to Moses. Remember when Moses had to hide behind the rock to be able to see God, and he only saw a part of just like the backside, and then it was just so powerful he could barely take it. And I was wondering how they reconcile, because if God can, I assume that most Unitarians, much as I was back in the day, are going to have a problem with that, because they can't just invoke agency. There has to be something there, like where God in some form even if he's muted the full potential of his power, still appears before Moses. And if that's possible for him to be in time space with his creation, and to have, even if it's just for a moment, that appearance, which, I think it's ironic, because that's the parallel that we find with Jesus at the Mount of Transfiguration, right? Which I don't think I've ever had any Unitarian be able to explain convincingly, because those two are parallel to each other. Christ takes off the veil, if you will.
Right.
So in your interactions, what has been the conventional response
it's interesting
regarding those two?
You bring that up, because it actually came up a little while ago, because they were actually applying agency, because I really asked that, because they were saying, well, every time you see him interacting, it was an angel. And I said, well, because I was thinking about the text, I said, I don't talk to him like a normal person, a vision or something like that, but I talk to him face to face. It's an intimate form of communication. And they said, well, no, you got to understand, is really. And I said, wait a minute. Well, when he said, show me your glory, and if this is an angel, well, why would an angel be veiling himself? Because people see angels all the time. What's so great about, a normal angel, just if this is just a normal messenger, right? And I said, well, if he was asking for the angel to see his glory when he hit him in the rock, and he said, I'm going to pass by you and I'm going to allow my glory, what was he seeing? Like a really buff angel? Like was he just seeing like a really big angel at that time? Like what was he seeing?
Right.
And they said, well, I didn't get an answer, and I probably should have kind of. I probably shouldn't have been so mocking, because that could have been a really good evangelism point. I'll be honest, I was a little irritated, because it was just, I felt like they were kind of like the question didn't make good sense. But I was like, what was the whole why was Moses, he received the law from angels, but then he's going to ask to want to see an angel? Like, you've seen angels. What's the big deal? You've already seen an angel before. But I never got a good answer on that. It was always this appeal to agency, and this has to be the case, and just never got a good answer, and it's interesting you bring that up, but I was like, that doesn't make sense.
And with the Mount of Transfiguration, what's the general response for that? Is it something like, well, Moses was glowing when he came off the mountain, but Moses is glowing because he saw God's glory, whereas Christ is literally taking off the veil. Like, they saw this bright light that none of them could even bear to look at. They had to shield their sight. How does that make sense in light of this idea of just, because if they're saying agency was, well, the angel, because, the angels are bright, and, either we're propositionally saying that Christ is an angel, or we're saying that, something is occurring that doesn't occur with any other biblical character in a parallel fashion. Not even Moses, because Moses shining had to do with God's glory, right? But Christ is shining in a way where the implication is, in keeping in mind that he was there with Moses and Elijah, in a way where Moses and Elijah aren't glowing in that fashion, right? And they're there presumably spiritually. So how in the world is it that Christ is glowing in such a fashion that, or has a brightness that just invokes? Because the first thing when I read that in the New Testament, as a believer who is now willing to accept the deity of Christ, it immediately invoked God and Moses in the Old Testament. That's the first thing that came to mind. That tie-in,
Right.
That tie-in is just unmistakable.
Those pictures to me, it's, and I would say, like, even if one tries to, I would say a person would at least need to be an Arian to have a coherent argument on something like that. Because what normal man could? That's just something normal people don't do. I mean, like, I've met a lot of people who think they're glowing, but I fail to see. And now, again, I've seen some of the adoptionists kind of make some kind of arguments that because of the ascending of the spirit, the most high, I've seen some kind of weird kind of arguments, but just like the straight conventional Unitarians, I be honest, I've never seen like a really good argument on this subject.
Yeah, that's a bit of a strange one. I've never gotten a satisfactory answer. And when I was embracing Unitarianism, um, prior to being saved, in my case, I didn't have an answer for that. I would try to, Moses was shining, but if you think about it, the two are so clearly different. You can't make a clear parallel between those two propositions because Moses is caused to glow by someone else. Jesus is glowing independently in a way where it's like there's no, well, an angel appeared before Jesus and now Jesus is somehow glowing. Jesus is literally, the brightness of his glory is just so great that everybody there, the apostles who were there had to cover their eyes. They had to shield their eyesight. That doesn't strike me as just a mere agent, a mere whatever it is that they attempt to invoke. So I think those two examples, and along with others, I think there's a plethora of examples in the Old Testament that point to Jesus being the Almighty God. And I think the problem is that their perspective assumes modern Judaism's take on the Godhead, because if you think about it, modern Judaism, because they'll usually invoke Jews, they'll say, well, Jews didn't believe in this. Well, Jews clearly believe that it wasn't impossible for God to incarnate in some form, or not. Let me not say incarnate. That seems, Jews didn't think it was impossible for God to be amongst his creation. You can find this in the sages. There were sages that believed that God was literally appearing to Moses, that God was literally walking in the garden with Adam. You have sages that believe this. The idea of flat Unitarianism comes about later, and it's a reaction to the Christian faith because Jesus is being identified as that God of the Old Testament.
That's true.
So I think, yeah.
No, that is, especially when you talk about like the interaction. And I was reading a little bit of Benjamin Somer the other day. I believe that's Benjamin Somer, The Bodies of God, if I'm not getting mixed up. When he's dealing with the concepts of divine fluidity and all those things. The from everything I'm reading, there was no concept that God didn't interact with his creation. Second Temple period and everything I can even tell from the ancient Canaanite world, a little bit I do understand. There was no concept that God was like barred from dealing with his creation. That's a very I don't know, that's a very foreign concept from everything I have read and understood, of at least how they and of course I'm sure there's somebody that understands it a lot better than I do, but I haven't seen that concept that he's just so far removed and stoic from his creation. And there is, it just, I don't know, it's like they just make some of these, not all, because I do believe there are some that are a lot more honest on their approach, but these are very odd claims that, and I guess that's one of the things that just kind of like in having some conversations, because I wasn't aware that some, I guess, appeal to some of these late rabbis from the 16th century so much, which I'm not saying that the arguments or some of the literature can't be interesting, but I'm like, yeah, you don't think that's odd? Like these gentlemen are, not to say you can judge their academic rigor just by that, but yeah, it's like, well, they are reforming their view to deny any type of thing that would be comprehensive to the view of Jesus being the Messiah. But I don't. When you were Unitarian in a conversation, let's say if it was a one who affirmed, let's say, an Islamic position, would there be a compulsion to push, someone who held a view of the deity of Christ in a conversation, or to, let's say, like if you had a help or a mom Yeah. Yeah, and I think it's a human thing. We can, especially like if we really involved in the conversation and we're kind of losing track of context or something's going on, especially if it's a personality type that has us really kind of wound up. Because sometimes certain personality types I find more than anything can really get us going. Now, we we can get as humans more just kind of like I got to get this person to see what I'm saying, and it can be kind of hard at times, but and I can't say I'm above that. I think, especially as men, I think they're just a part of our nature, unfortunately. But one thing I can say is, for instance, and I know everybody know I'm not a Trinitarian, but if a Trinitarian is talking with a Muslim, as much as I have my views on the doctrine, I'm not going to help a Muslim. I'm not going to help a Muslim. If a Trinitarian is talking about the deity of Christ, I'm going to shut up. I'm going to just shut my mouth for the time being, because to me, I feel at that point it's really not that important in retrospect. I'd rather the person be a Trinitarian than a Muslim, because in my mind, I in my mind, I know you're going to hell if you stay a Muslim. I mean, there is no question in my thought process. But I have seen some instances, like of course, I'm not saying all of the Unitarians do this. That is not my accusation. But I have seen like a few instances, like when Albie was talking to me, and I think everybody know me and Albie have had our disagreements theologically, even though we're on good terms, just kind of going behind some guy that he was Muslim he was talking to and trying to tell him don't believe Jesus. I'm just like, is that really that important to do at that moment? The guy was just a Muslim. You don't think you could just leave him alone at the moment? Maybe that's not the most important subject to kind of hit at the time. Maybe him kind of coming out of Islam is probably what should be the top priority right now. Then later on, if the guy's curious and he approaches you, then kind of to if that's what needs to be talked about. But I think sometimes people get so involved into trying to prove their point that they just go the wrong way. But I don't know. That was just some of the things that were on my mind. Actually, the gentleman I was on a gentleman's channel a little while ago. I had a debate with a guy named Faithful Theology, and he has a big YouTube channel. He's wants me to come on tomorrow, and we're going to talk on some things. So it's going to be interesting tomorrow. But he has a very nice personality, so I'm looking forward to talking with him. But yeah, it's Unitarianism is very new to me. So I'm learning from a lot of different sources on how to approach it and how to understand it. So I want to try to get a better grasp because so far I have a base understanding of it, but there's a lot of variance, at least from what I've encountered. But want to try to see if there's like like when you talk to at least most Trinitarians, you can find like, okay, I know what most Trinitarians believe in most areas, but when dealing with a lot of Unitarians, man, it's kind of hard to get your finger on it.